My name is Angharad Hurle and I am a legal director specialising in inquiries, inquests and confidential investigations. Today's episode of Through the Inquisitor's Lens is titled To CP or Not to CP, and I am joined by Clive Smith, President of the Haemophilia Society, who was a co-participant in the infected blood inquiry. This episode was recorded a couple of months ago when I sat down with Clive to discuss his experience of being designated a co-participant in the inquiry. Clive and I had a lot of ground to cover, therefore this has been broken down into two parts. Part 1 will cover the campaign for a public inquiry, why he decided to apply for co-participant status, and assimilating vast volumes of evidence in a short time frame.
So thank you for joining me today, Clive, to discuss the question of to CP or not to CP, to reflect on your involvement in the infected blood inquiry as an individual co-participant and as the then chair of the Haemophilia Society. Having served as the chair for 5 years and 9 years as a trustee, you are now the president of the society. You are active on the global bleeding disorder stage and have spoken at both the World Federation of Haemophilia and the European Haemophilia Consortium's conferences. You chair the World Federation of Haemophilia's Youth Committee, and in 2021, you were appointed to the UK Rare Diseases Framework Board as a patient representative. You're a qualified criminal barrister and now teach and train solicitors and barristers. You were born with severe haemophilia A and have worked tirelessly to raise awareness about bleeding disorders and what can be achieved whilst living with a severe bleeding disorder. I had the pleasure of representing you and the Haemophilia Society and some of its other members as co-participant in the infected blood inquiry for 6 years. Can you please tell me a bit about your campaigning for the infected blood inquiry over the years?
Of course. Hello, Angharad. Happy to talk about that. I suppose I should start more broadly by talking about the society's involvement, because as you say, I was on the board for 9 years. I was chair for 6, and in terms of my being the chair, it was complete coincidence that I happened to have someone with severe haemophilia and who had a legal background being chair at the time. And when the inquiry was first announced, I became chair of our subcommittee, which we formed internally to deal with this, and our then chair Barry Flynn stood down as chair after only 3 years because he became the VP, the Vice President of Finance for the World Federation, and so the board very kindly asked me to take over from him. The society itself has been campaigning for decades, and I should say alongside many other groups as well. Said, isn't it, that success has many parents whilst failure is an orphan, and I don't think anyone can claim credit themselves for having achieved the inquiry. It really was a group effort from the community. Yeah. So the society, I think, first called for a public inquiry as long ago as 1989. I was 9 years old at that time, so I wasn't actively involved in any sort of campaigning, but obviously I was very aware of what was going on in the community, even as a young person, I think. And then back in 2015, as you say, I joined the board, and then in 2018 became chair, just months after really the inquiry was announced. And the campaigning has never gone away, because although so initially in terms of the legal history, so people were infected obviously with contaminated blood during the 70s and 80s. In 1989 there was litigation against the government by those who were infected with specifically with HIV, yes, known as the HIV litigation. And that litigation against the government was settled. The trial judge hearing it, Mr. Justice Ognall, took a rare intervention, saying that the people who are taking this litigation are unlikely to be alive at the end, so you should really consider your position as the government. And they did, and there was a financial settlement of sorts. But I think two things. Firstly, I think people never felt that financial settlement was adequate. People took what they could at the time because they were desperate. They were literally dying. And some people spent it on buying a nice car and going on holiday, and they were dead within a year or two. These were literally people who were taking money to make memories before they died. The second aspect of it, and this is a broader point in many inquiries and inquests, people wanted to know the truth. And by settling in court, we never actually got to fully examine how we got to that stage and that position. So the campaign, and for so many people, they've lost their loved ones, and no matter how much money you give them, as you know, money can never bring back your loved one. So what they wanted was the truth. They wanted to know why this happened. They wanted to know, could it have been prevented? Was it simply an accident? Was it simply something that was terribly unfortunate, which is the way in which Sir John Major characterised it when he gave evidence to the inquiry. And I have to say, I should be fair to him, because I felt his evidence when he gave evidence to the inquiry was incredibly balanced. And he arguably, in my view, my humble opinion, made maybe one misstep by saying that the haemophilia community were just incredibly unlucky, because people felt that they weren't unlucky, because if contaminated blood was ever going to impact anybody within our health system, it was going to be those who relied on blood products. It was never going to be people with diabetes, for example, or any other medical condition. So say that campaign for the inquiry has never really gone away. I suppose the next aspect of all that is, how did we then achieve an inquiry after so many years? Because I've been at a meeting recently in London with the Paymaster General and the Lord Chancellor, and it was a listening day arranged by Inquest, the charity. And there were many other groups of people there who've been wronged by the state, Hillsborough, Grenfell, Primidos and Valparaiso, all the Cumberledge, all those encapsulated in the Cumberledge Review and those sorts of things. And I think probably those who are impacted by those medical products in the Cumberledge Review, probably what they do predates the contaminated blood scandal. But apart from that, I think everybody else time-wise, and the nuclear test veterans, of course, as well, everybody else postdates the contaminated blood inquiry. In terms of actually achieving the inquiry in the end, I think there were three broad things that were going on. Firstly, the government of the day were being sued. There was a group litigation order being taken by a particular lead claimant, Jason Evans, who's been a very strong campaigner over the years as well in relation to all of this. And so this was back in the public conscience because of that. And they were challenging what was known as the waiver. So I didn't mention that when I talked about the 1989 litigation. When that litigation was settled, people had to sign a waiver. And one aspect of that waiver was that you wouldn't take action against the government in relation to any other blood-borne infections. And that was signed back in 1989, 1990. The first test available in the UK for hepatitis C didn't become available until 1991. So people were effectively signing away their rights to something they didn't know existed. So that was part of the challenge to the waiver. The second really significant thing that was going on was that Andy Burnham used his valedictory speech in Parliament when he stepped down as an MP to become Mayor of Manchester to talk about the contaminated blood scandal. And he talked about having evidence of a criminal cover-up on an industrial scale, and said that if the government didn't launch an inquiry, he would go to the police with this evidence and say that they must investigate it. The third point, and I think this is always a factor to be borne in mind with all these things, was the political position. So Theresa May was the Prime Minister, there'd just been a general election. They had a confidence supply arrangement with the DUP at the time. And all the leaders of the opposition parties had written to the Prime Minister of the day saying, you need to announce a public inquiry. It happened incredibly quickly to the extent that she told her cabinet on a Tuesday morning, and it was on the lunchtime news at 1 o'clock. Sometimes you'll have more experience of this, Angharad, and others may be listening. These things are embargoed, and you know about them for maybe a very short time. We knew about it for literally hours, and I know the staff team at the Society watched it on TV as it was being announced at 1 o'clock, and their jaws were on the ground because they couldn't quite believe we got there. Ironically, we had a board meeting the next day in London. I still remember now walking through Leeds train station, travelling down from Yorkshire to the board meeting and looking at the front page of the Yorkshire Post, and it was headline news.
It's been quite a journey for you, hasn't it, Clive, to say the least?
For everybody and the community to get there, but we did get there, and it's all been worthwhile to that extent.
Yes. There had previously been some other inquiries set up, though, hadn't there, before the UK government actually announced this wide-ranging inquiry, as it were. So there'd previously been the Penrose inquiry in Scotland, the Archer inquiry, and also the Lindsay inquiry. So why was there still the need for this overarching inquiry, do you think?
Well, as you said, that the Lindsay inquiry happened in Ireland, so we had an idea of what had gone on here, because much of what happened, not identical, but a lot of what happened in the UK had gone on in parallel in Ireland, and we'd obviously been in contact with our counterparts there, and in Canada as well. Of course, they'd had the Quiver inquiry. So in terms of what had happened directly in the UK, in terms of the Archer inquiry, Lord Archer had set up an inquiry. It was a non-statutory inquiry. And for that reason, as your listeners will appreciate, it couldn't compel witnesses to attend, they couldn't compel evidence either. Some good came out of that. So the government did accede to funding the society, or providing some funding for us over 5 years. So we received £500,000, so £100,000 each over 5 years. So some good came in that respect. But in terms of answers, in terms of actually a full examination of what had gone wrong and what had actually happened, it didn't feel like that had really taken place, despite best intentions and best endeavours and hard work from many, many people during that. Then, of course, we had Penrose, which you've alluded to, which took place in Scotland. Penrose took a very long time. Lord Penrose was not respected at all, I think, by those who were certainly those who were members of the community who were involved in all of that. And it only came up with one recommendation, which was that there should be a look back exercise into those who've been infected with hepatitis C through blood transfusions. So it wasn't felt that that achieved much at all. Although in saying that, I should say this, that if my counterpart, former counterpart Bill Wright, the former chair of Haemophilia Scotland, was here, he was involved very heavily in that inquiry. And he said one of the good things that came from it was that they were able to conduct a clinical review in Scotland, which actually looked at need for those who'd been infected. And as a result of that, the support payments that people who've been infected received were increased in Scotland. So part of the litigation back in 1989 resulted in something called the McFarlane Trust being set up, and payments being made to those who've been infected and their partners, should they have been infected themselves, and should their loved one have died. And so during the currency of the inquiry, we actually managed to use that as a stick to beat the Westminster government with, to say, oi, the money is not the same in all the devolved nations. It depends which country you're infected in. We did manage to achieve parity ultimately during that. But in terms of going back to why it was felt that that inquiry was still required, it really goes back to the point that we discussed earlier, that people still wanted the truth.
Yes.
Not only that, but I think people wanted acknowledgement for what they've been through. And I don't want to suggest for a moment that grief is a competition, but if you mention Hillsborough, if you mention Grenfell, if you mention many other tragedies, people know what they are. And they are sadly very easy to explain and to describe to people what happened. Whereas if you describe what happened to 5,000 people with haemophilia and bleeding disorders, you need to explain what the condition was, why they needed that treatment, why it had to be imported, how they became infected. It's not an easy story to tell. And I think for so many people who'd lost their loved ones, particularly children, they wanted some acknowledgement and they wanted some recognition, and obviously they wanted the truth.
Yes. As I mentioned at the outset of this, you were granted co-participant status in the inquiry, as was the Haemophilia Society. For those that don't know, a co-participant is a certain category of participant in an inquiry and is required to make a formal application to the chair to be granted co-participant status. In order to be designated a co-participant, the chair must consider 3 areas in accordance with Rule 5 of the inquiry rules. And the 3 considerations are whether the person played or may have played a direct and significant role in relation to matters to which the inquiry relates, the person has a significant interest in an important aspect of the matters to which the inquiry relates, or the person may be subject to explicit or significant criticism during the inquiry proceedings or in the report or any interim reports. What was it that made you decide that you wanted to be a co-participant in the inquiry, both on a personal level and also why you thought it was important for the Haemophilia Society to be a co-participant?
I was a patient at Great Ormond Street growing up, and that's where I received my care along with my 2 brothers. And I lost my very dear friend Stuart, who was co-infected with hepatitis C and HIV, and so it had a profound effect on me, because the haemophilia community is it's quite unique. sometimes describe it as the Hotel California. You can check out, but you can never leave. So, as you mentioned earlier, I'm no longer the chair of the society, but I'm still the president. They've not let me get away, not that I want to. And it's a very close-knit community. It's not an underestimation to call it a family. It really is. And so if something happens to your friend, your blood brother, effectively, then it occurs to you, and it's really hard when something like that happens. That somebody you grew up with and spent so much time with at hospital appointments and all those things, and time outside those as well, is taken away by something which you feel shouldn't have happened, could have been prevented. It's personal, and so that's why I wanted to be involved. And obviously you've alluded to my involvement in the community more broadly. So it was never something, the inquiry was never something I could sit on the sidelines and watch. I was never going to be a spectator. The question was how far involved I was going to be. And as you say, I decided to apply personally, which was granted. And then obviously the society itself was granted core participant status for two broad reasons, really. Firstly, we were named in the terms of reference, which I think was significant and important to mention. We were named because back in the early 1980s, we had given advice to our members that the treatment that was being prescribed at the time, as far as we were aware, was safe, and that people should continue to take their medication. We now know that the advice we were given was wrong. Professor Arthur Bloom, who was chair of our medical advisory board at the time, was lying. There's no other way to put it. He was lying. He was concealing. He was giving advice as the lead clinician of the UK Haemophilia Centres Doctors Organisation that children should not be treated with imported blood products, and yet months later he was treating his very own patients with those products. It beggars belief that he did what he did. It beggars belief that he gave the advice that he did, knowing the potential impact that could and indeed did have. We will never know what his motivations for that were. He died in the early 90s, so he was never called to the inquiry to account for his actions. But I think it's fair to say that there are chapters of the inquiry that are devoted to his involvement in it all. So, and that's not to underplay our role in that, simply saying that we followed what he told us. I think the chair said that we should have been more critical of that, and I think that's a criticism we absolutely accept. And one of the big lessons from all of that is that we don't give advice to our members on treatment anymore. We will put out information. Only this week there's been a new treatment license, and we've said, here it is, this is what it's about, and go and discuss it with your clinician. So that's certainly not our role, and that was a very hard lesson for us to learn. And I say that because our board were infected and affected by this. I think nearly all of the board at the time. And we have to remember these were days when WhatsApp and the internet and even phones were not regularly used, didn't really exist. And there were times when our board used to turn up for board meetings and you wouldn't know who was going to be there because you didn't know who died between board meetings. That's quite a shadow to be operating. So we were included for that reason, and obviously for the other reason, the fact that we are the Haemophilia Society and we've represented our community for decades. We're nearly 75 years old now, and we've been around rather a long time and had a skin in the game for some time, as some people have described it. So we saw ourselves, to use a legal phrase, as sort of claimant and defendant, or claimant and respondent. And I use that language reluctantly, because one of the big lessons that I learned, certainly coming from an adversarial background in terms of litigation, was that this was very much more inquisitorial rather than adversarial. And that was something that we had, certainly I had to adapt to as in terms of my background.
Yeah. So in terms of being a core participant then, and I suppose your background, as you say, is adversarial, and this is very inquisitorial. Being a core participant, you have certain privileges where you have advanced sight of documentation, witness evidence, and you're actually given the opportunity to propose questions for witnesses, which is very different, a very different style, as you've already mentioned, to what you're used to in your professional, your background. So how did you find that process?
It was was challenging in many ways, in the sense that it challenged me. I think it challenged us as an organisation, and it was, I say, a change of approach. I think, as you may be able to say more about this, Angharad, that we didn't receive a lot of notice about a lot of things, and so we found that it was feast or famine. We either had hundreds, sometimes even thousands of pages of things being disclosed to us, or there were these low periods where not much was going on. So you either you're on sort of hyper alert for another witness statement of Lord Kenneth Clarke to be released, or it was a case of, well, nothing's really happening at the moment, isn't it? So and so I suppose I'm used to that, in the sense of, I could be thrown a brief the night before and be told, there we are, turn up to whatever Crown Court tomorrow and get on with that case. And so I'm used to being able to absorb and digest information like that, then having to respond. But I think not knowing when it was going to happen all the time was a challenge, because it wasn't just me saying, Angharad, ask this question or you'll do this. We had to work collectively. I've already alluded to the fact that our internal structure, we had a subcommittee within. We couldn't involve the whole board on this. Just would have been impossible to have had the whole board involved. So we had to have a distilled group of the board on this subcommittee. Then alongside that, we had our staff team who were amazing. So we had Kate Burt, our chief exec, who came in as chief exec in the very early days of this and had to get up to speed very quickly. We had Deborah Morgan, who led on this and was the main liaison with you. We had Jessica Bomford, who was our dealing with our communications and media, etc. And then we had Jeff Courtney, our head of policy and affairs. So we had all those people feeding into all of this. And I think that was really helpful, because we all came at it from different perspectives. Of course, I should mention Katie Gollop, King's Counsel, as well, who was rather good.
Of course.
She'd occasionally have a question or two that got asked when she had hands. So I think I got my hat-trick ball one day. I think Jenny Richards might have, or we did. I think we got Jenny to ask, lead counsel, Jenny Richards, King's Counsel, to ask 3 questions one day. I think we were privately celebrating out the back. And we finally hit our stride, haven't we, in terms of getting the right questions. So it was challenging in terms of having all that information to absorb and digest, and then having to discuss it internally in terms of what was important to us as a core participant, which bits we could leave alone, which bits we knew other people would pick up on, because if we didn't have time to do it, you say, well, we'll leave them to lead on that bit. We should be focusing on this. And we very much, I think, when asking these questions, obviously there were personal questions that people thought, well, I want that to be asked. But equally, we had to stand back and we had to try and feed in and engage with the community and say to them, look, if there are specific things you want to be asked as well, you need to let us know. So we very much had to put ourselves in their shoes at time and say that whilst that might be of particular interest to us, we know actually the community are going to be more broadly concerned with this aspect of it. So looking at it, so I think absorbing all that information, managing to digest it and deal with it internally as that team, managing to take a step back and deal with it in terms of how we thought the community would best want to approach it, and then formulating the questions in a way in which we knew lead counsel might be attracted to it and think, well, yes, that is a relevant answer. And I think lots of what we did, and I think Katie Gollop was very good at this, and you were, Angharad too, was saying, just tie everything back to the terms of reference. Yes. And I think if I could give anybody listening to this advice now, you have to, again, put yourself in the chair's shoes as well, or whatever he or she is looking at. How is this informing me? How is this helping me get to the answers that the questions in the terms of reference have posed? And as soon as you could attach what your question or your area of thought or examination to an area of the of the terms of reference, then that's when I think we started to hit our stride a little bit more and feel like we were a core participant and not just a core spectator, for want of a better word, in the inquiry.
Yes, and I think that is really important, isn't it? When you've got to have the internal structures to be able to digest everything, because, as you say, at times the pace of information and evidence coming out of the inquiry can be extremely overwhelming, and that is simply because there is so much going on at the same time, particularly with an inquiry like this, where the chair was very keen to be as thorough as possible, but also to proceed at pace. For the reasons you've already mentioned, that the chair wanted to hear from as many of those who have been infected and affected as possible, and also wanted to be able to report when as many of those individuals were also going to be able to see the end of it, unfortunately. And that was, I think, something that we were all acutely aware of as the inquiry progressed. So at times, yes, we were having thousands of documents coming out. We had a team looking at those documents, digesting them, identifying the key ones that were relevant to the society, informing you of the content of those, and then considering what questions, if any, actually, because that was the other consideration, is whether it was actually appropriate for the society to be asking certain questions as well. And I think that's the whole communication point, isn't it?
Quite. And I said this many times in meetings, as you know, Angharad, the art of the advocate is not in what you do say, it's in what you don't say. So there was absolutely aspects of that we had to decide. Actually, we're just going to remain silent.
Yeah. And I think then building those relationships as well, as you've mentioned, obviously we had Katie Gollop, Casey, who was lead counsel for the society, and she developed a relationship with the lead counsel for the inquiry as well, to be able to have those discussions around what was really important to the inquiry in certain phases of evidence as well, and whether now was the time to ask the questions, because sometimes actually now wasn't the time, but 2 months down the line, it would have been more appropriate to ask that question. So I think having that experienced team on board to support you, but also you having that subcommittee to filter and be able to take that step back but pull all the information together was actually very helpful for us as your legal team as well.
Thank you for joining us today. Part 2 will be published in 2 weeks' time. Make sure you don't miss it by subscribing to Through the Inquisitor's Lens podcast.